Okay, everyone, so welcome to today's webinar, which looks at suitability matters before and after admission in Queensland. I'm Carly from Community Legal Centres Queensland, and with us today we have Bill Mitchell from Townsville Community Legal Centre. So before we get started, I'll just make sure that everyone can hear us. So if you could just press the button that looks like a hand on your control panel, I'll see those hands go up and hopefully people can hear. It looks like I've got some hands going up. That's fantastic. So I think everyone can hear us, which is great. So firstly, I'll do a acknowledgement of the traditional owners of the land on which we're holding the webinar today. So in Brisbane, they're the Turrbal and the Yagara people, and of course we have people listening throughout Queensland and Australia. So I'd like to pay my respects to all of their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. So today, as I mentioned, we've got Bill Mitchell from Townsville Community Legal Centre, and he's going to be speaking to us about some of the suitability matters that are really important for law students to take into account before and after their admission into the legal profession in Queensland. So many community legal centres host students in clinics or through their PLT placements, and often CLC solicitors also move the admission of those students. So in the lead up to admission, students have to disclose a range of matters. Some of those are quite underappreciated, such as academic misconduct, Centrelink overpayments, infringement notices, and also traffic offences. So Bill will talk to us about some of those, and I know that we've got some law students on the webinar today, so hopefully this will be really helpful for you as well. So today's webinar is going to be recorded, so for anyone who isn't able to listen to the live version, hopefully you're able to download the recording later this afternoon from our website. And Bill's also provided his PowerPoints, which we've emailed out to everyone and also popped up online as well. So what we'll do throughout the webinar is Bill's happy to take questions during his talk. So there are two ways you can ask questions. You can press the button that looks like a hand and we'll see that hand go up at our end, and we can unmute you and you can ask your question via your microphone if you've got one, or if you don't, you can just type your question into the question box on the control panel and we'll read your questions out. So we'll also leave around 10 minutes at the end for questions, but if you do have any burning matters throughout the presentation, feel free to pop them through and I'll just read those out for Bill to answer. So without further ado, I might hand over to Bill now. So Bill, take it away. Thank you very much.
Okay, thanks. Hopefully everyone can hear me okay. This is a subject that is probably a little bit out of left field for us, but certainly I've encountered the issue enough that I thought it would be worthwhile for other CLCs and other people involved in CLCs to learn a little bit more about. Certainly it's an area that can throw up some real challenges for us when we are looking at our students moving into practice. And in fact, it throws up challenges for us, for our own staff and for volunteers who may have these issues in practice. So I'll run through today a bit of the regime. Here's an overview of what I'm going to talk about. First, we'll talk a bit about the relevance of this topic to us all. Then I'll touch briefly on the Supreme Court's jurisdiction. I'll talk about admission to the profession and what that involves and the steps involved, but I won't dwell on it too much because really what we want to talk about is suitability for practice. I'll try and reflect also on how some of these issues are actually ongoing conduct issues and related back to a solicitor or barrister's obligations under the Legal Profession Act. We'll talk about the sorts of things that might not only be a suitability issue for us getting admitted, but also for us when we're engaging in practice, because it can be complex and difficult to know what to do when these things arise for our colleagues or for our volunteers. And then I'll talk at the end about some practical matters that have come from some of the work I've done. We at Townsville have been involved in a range of suitability matters, including applications for early suitability and contested admissions. And so I think it's really important to appreciate that this is no longer a straightforward process. The process of admission can throw up all kinds of quite serious questions for the candidates or the applicants. It can throw up very serious questions for you if you're a mover or you're assisting someone to be admitted. So hopefully we've got a bit of a ready reckoner here today to let you learn a bit more about what the issues are involved. So let's make a start. Let's first talk about relevance. Well, look, CLCs are clearly a training ground for law students through clinic, through internships, through placement programs, and also for law graduates, PLT courses. And so the number of CLC volunteers that come through who are law students is very large. It's much larger than people would see in private practice. It's much larger than you would see in barristers' chambers. And so we are probably, along with legal aid, the primary training ground for law students who are moving from having completed their undergraduate degree into legal practice, whether it's through work integrated learning programs such as clinic, or whether it's through more formal programs such as PLT placement. It follows from that CLC lawyers are often asked to move admissions for new lawyers or for applicants to be admitted. And this is the point in time that you really do need to have an understanding of the system. As I said, it is complex, and the more you know about it, the more comfortable you'll be possibly moving admissions or assisting students who have some of these issues arising. It's very disappointing to me that law schools really seem to ignore the importance of many of these issues. They don't teach this issue, or I should say they don't raise this issue comprehensively with students when they need to know, which is at the outset of their studies. Many of these issues, as you'll see, are issues that arise during the time of their study, if they are school leavers, or have arisen already in their lives if they are mature age students. And so we find ourselves with law students who come to the end of their degree, they are engaging in the process of being admitted, and for the first time they realise they have an issue which may prevent them from actually being admitted despite their 5 or more years of study. It's a very stressful moment for them. It's a very difficult area to advise in because of the fine balance the court looks at. And so we, I think, as practitioners need to take some responsibility to ensure that we are engaging in this process, to ensure that students who have suitability issues have the best chance of being properly admitted. And of course, the flip side of that is to ensure that those who are not suitable for practice are given proper advice and understand their options. And in the cases we see, or I've seen, not everyone gets admitted. That's actually the case, and they're the ones you don't hear about, the ones where students withdraw their applications because of advice they get, or where they're refused by the court, or where they are refused early suitability. So there's a darker side to this for law schools, where students who probably should have known from the outset that they were not going to be admitted find themselves very late in the piece, struggling to understand why they will not achieve their dreams because of something that's happened during their law school days or in their previous life. The Supreme Court's jurisdiction in the case of admission of lawyers is very long-standing, and I've noted the case of Costello there, 1889. So the courts had this jurisdiction to admit lawyers as well as to regulate and discipline lawyers for a long time. And when, in the early days, the court was looking at what things should it consider in order to admit someone as a legal practitioner, even back as early as when we had a profession that involved not just solicitors and barristers, but also proctors and conveyancers. But even in the very early days, they looked at 3 principles. That is, if you had something to disclose, that you were open and candid about that disclosure, and that you showed repentance or remorse. Now, these are very fundamental principles that continue through the cases and the court's history. It's very important that you understand that these fundamental principles still direct the work of the court when it's looking at these cases, and they can be turning points for your case if you have one or if you're advising. The Legal Profession Act, of course, in 2007 created a referred jurisdiction for the court, which replaced the common law jurisdiction, and it's a jurisdiction that is clearly marked out for students at law who are entering the profession and for lawyers who are already in the profession, whether they be admitted or from another place and seeking admission or practice. There's three areas that we first look at in terms of how this process works. And most of you have been admitted if you're lawyers, or you're looking at the process if you're prospective lawyers, but it doesn't hurt to have a quick run through. The first thing we need to find out is whether we're eligible for admission, and I'm not going to go through the bits and pieces, but Section 30 of the Legal Profession Act says that you must first find eligibility for admission. Following on from that, it's important, and eligibility, I should say, relates mostly to academic and practical legal training. So do you have the approved academic qualifications, and do you have the approved practical legal training? This should not be confused with suitability, which is sections 31 to 33. Suitability, of course, is much more about whether the person is a fit and proper person to be admitted. And we're going to talk about that in detail. This is the role of the court. And then, presuming that you satisfy those things, there is an admission process, section 34 and section 35. And that says that a person may apply to the Supreme Court to be admitted, and they've got to make an application in a certain way. It is sometimes misunderstood, and it shouldn't be, but an application to the Supreme Court for admission is an application like any other application to the Supreme Court. It involves an application process, written documents, and a hearing of some sort. So I said the admission process should be clearly understood as having two separate parts. The test for eligibility, which is marking off the things that you have to do as a law student academically and practically, as well as suitability, which is marking off the things that make you an appropriate person. The application itself is ruled by section 31, and this talks about suitability. It says a person is suitable for admission to the legal profession only if the person is a fit and proper person to be admitted. Following on from that is a process that's very important for us to know about, which is called the early consideration of suitability. And this is where the Legal Practitioners Admissions Board is able to look at applications prior to them going to the Supreme Court. We're going to talk a bit about that later. Section 34 says that all applications must be in the approved form, manner, and in accordance with the rules. And anyone who's done their admission knows that there's a myriad of things you've got to tick off, and all of these rules that apply in terms of advertising and having applications put in at this time. So there's a process you've got to go through. So even when you are eligible and suitable, there's a rather complex application process. I'm not going to touch on that because this isn't about the procedural issues. This is about the substantive issues that arise for suitability. It's important to realise that the onus is on the applicant to prove fitness. This is very important. I'll let you read this quote yourself. It's a quote from the Supreme Court in a case called Doolan. And in that case, they were looking at what the Supreme Court's role is. And in fact, it's very clear that the Supreme Court's role is to consider each of the suitability factors if they arise. It can't ignore any of those suitability factors. And Doolan's case was about a man with mental health issues who had applied to be admitted, and they were looking at the very last of the suitability factors, which we'll come into in more detail later on. And so this was the court saying that they are required by statute to consider each of the suitability matters. They can't ignore them. None are diminished in any way. So let's talk first about the process of early suitability under Section 32. Where a student at law, someone who's making an application, has a matter that may adversely affect their assessment, and that means that they have something that may cause the court to have concerns about whether they're a fit and proper person, and that would include any of the Section 9 factors, and there's a good number of them. And it may also include the sorts of things that are discussed by the Law Admissions Consultative Committee guidelines. It is very important that you're aware that the suitability requirements at Section 9 of the Act, which are prescriptive, have this complementary guideline document, which actually includes more things than are listed in Section 9. And we're going to come to that in a bit. But just be aware that wherever a matter may adversely affect assessment, a law student or an applicant can apply for early suitability. An application has three possible outcomes. The first is that the Legal Practitioners Admissions Board makes a declaration. They might refer the matter to QCAT for a direction, or they may refuse to make the declaration. Now, it's important also to understand that irrespective of what the board says, the discretion to admit a lawyer remains with the Supreme Court. Section 35 allows the court to rely on a recommendation, and in fact, if the board refuses to make a declaration, there is an appeal to the court from that refusal, Section 32. But it's very important to understand that the application for early suitability to the Legal Practitioners Admissions Board is not the end of the process. It is simply a recommendation, and we'll talk a bit about their role later, but ultimately the discretion remains with the Supreme Court. This case of KMB is a fairly recent case, and I'll let you read this quote, but it says that it's reflecting that the status of the board does not transform it into a normal party in the sense of parties in the court. It has a statutory role to make recommendations that help the Supreme Court about each individual application. Very important that you understand that the Legal Practitioners Admissions Board has a process of early suitability which a student can apply through, and then that will result in one of those three outcomes. Hopefully it'll turn up in a recommendation for admission, or a decision by the board that they will not oppose the application. Because as I said, they're not a party. Their only role is to make recommendations and assist the court itself. You want to have a look at that case, it's a good one to read. It's a very recent one. And it's important that you also appreciate that this is a very dynamic area. The sorts of issues that affect suitability are as lively as contemporary society. The sorts of issues that might have affected my admission in 1992 are very different to the issues that affect admission now. They've become broader, they've become more contemporary and more problematic for many people, I suspect. The Supreme Court hears the applications for admission under Section 34, and it's actually their role to hear and decide those applications. It can make a number of different, there can be a number of different outcomes, including the court makes an order admitting the applicant if they're satisfied they're eligible and fit and proper person. It can refuse the application, and any orders made can be unconditional or conditional. In determining the application, it may rely on the recommendation of the board. Suitability matters under Section 35 are noted by Justice Mullins in a paper of hers that I've included in the references. Very wide-ranging. It is a very wide-ranging inquiry. The requirement under Section 31 that a person be fit and proper is a very broad inquiry. It includes 14 separate suitability matters under Section 9 and a range of other matters. Some of them are very general, such as being of good fame and character. Some of them are quite specific, such as your insolvency status. As I said, do not forget that there is a complementary set of guidelines which tell students at law and applicants what they have to disclose. They are disclosure guidelines. And so if you don't get that right, if you have something in those guidelines or in Section 9 and it's not disclosed, then you immediately have problems. There's a question of whether the guidelines apply to post-admission suitability. The sorts of things that are noted in the guidelines for applicants are not listed necessarily as suitability issues for practitioners, and I raised the issue of family violence as one of those, and we'll talk a bit about that later. Post-admission, you will occasionally come across lawyers who did not disclose something and managed to get admitted anyway. If it was disclosed, then there's no real issue. If it wasn't disclosed, then a number of things can happen. The most likely thing to happen is that they need to disclose it. If it's a suitability matter and they haven't disclosed it, they need to disclose it. If they've already been admitted, chances are they will be refused a practicing certificate. It might also result in disciplinary proceedings. If you have a case like this where a lawyer has a suitability matter that arose prior to admission, if they fail to disclose, then you need to speak to someone who has an expertise in this area, because it can be quite tricky. Okay, so let's focus now on suitability. These matters are very broad and they generally arise out of section 9(1)(a), paragraph A. This says that the court must be satisfied that applicants for admission are currently of good fame and character. And this is an old principle that comes from the common law, and so it's been imported into the Act. Suitability reports can be obtained, and they can be obtained from the police or for health assessments under section 84. And this can be for those being admitted or for those who are already in practice. Health assessments are mostly about the person's mental health, and we'll talk a little bit later about how that impacts on our suitability issues. Suitability matters do not occur in a vacuum. Many of the people that you will see have a multiplicity of suitability matters. And there's a case there of Cohen. Cohen's admission was refused by the full court, the Jersey, in 2008. He had made applications for admission in 2007, 2008, 2009, and he finally came back before the court in 2012. His history included criminal matters, traffic history, bankruptcy, and poor compliance with ASIC requirements for directors. President McMurdo said of his application that he had an unimpressive background, and deciding whether he had demonstrated suitability was a difficult and finely balanced question. And I think she certainly gave us a good principle to address, that it is always a finely balanced question. So suitability never occurs in a vacuum. Likewise, Justice Mullins said in her article, a person's conduct may reveal their character. It's very, very important. Every one of the articles, every one of the papers you will read talk about the importance of candour and disclosure. You are far more likely to be refused admission for a failure to disclose or a failure to be candid than in many cases the suitability matter itself. And so when people are weighing up what they tell the court or the board in an early suitability application, you really have to look at the guidelines and look at the Act and be very broad about it. It's important to not keep matters secret, particularly if they might arise or become known. And we'll talk a bit about that later, how they can become known. The general principles are that many of these cases now have multiple suitability issues. For example, it's not uncommon to have multiple offending conduct. And there's a case of J.Y. In J.Y.'s case, he had criminal offences that occurred in 2000 and 2005. Then he had further offences while serving the Defence Force. He failed to disclose the Defence Force offences, and the court essentially viewed his case as one where his lack of candour in disclosing his Defence Force offences was his problem, not so much the offending conduct itself. And so his dishonesty in failing to disclose the offences was treated as more serious than the offences themselves. You'll find another case of Owen, which is a High Court case from New Zealand. And Owen says about dishonesty that it will be viewed as disqualifying because such criminal conduct will prove an indication of human frailty or defect of character, which is incompatible with membership in the legal profession. Now, how long does it take before these sorts of character issues become not problematic? So at what stage does the effluxion of time erase your flaw in character? The case of Borhani said that in some cases it can take quite a while. The case of Laveri is problematic because it says that depending on the conduct, and that was an academic misconduct case, depending on the person's conduct, they may never be able to demonstrate their fitness, because it may well be that the mere lapse of time would not warrant the court's conclusion that fitness had been demonstrated. And so we need to be very aware when advising people that the simple passage of time is often not enough. Again, I raise candour. If you go back to Davis and the High Court, it's a very comprehensive analysis of the importance of candour, and anyone who has a case like this should go straight to Davis. That is your starting point. Hilton, many people know of Howard Hilton's admission career. An understanding and acknowledgement of wrongdoing is vital because they want to know that there is proof that the person has been rehabilitated. This is if you are applying for admission or if you're applying to be put back on the roll after having been struck off. And Hilton was a case where he was applying to go back on the roll after having been struck off. There are, of course, specific issues we need to be aware of. Section 9 lists these issues. One of them is criminal conduct. And of course, the admission guidelines also talk about this. It's important to note that criminal conduct should always be disclosed, and it needs to be disclosed in a way that is precise, and so the nature of the offences is disclosed, not only the convictions or the detail, but often the board will ask for more detail about things, and criminal conduct is one of those. Look at the guidelines as well at 5A. There are many, many cases on this, and I'm not going to go through them. Your starting point is Zymes, which is a case which looks at the point at which criminal conduct crosses the line and becomes a suitability issue. The High Court, I think it was, said, generally speaking, professional misconduct has more of a bearing on a person's fitness, but there are stages at which their personal conduct will cross the line. And we're going to talk about those through these suitability issues. Lawyers have a statutory condition to notify of any conviction of offence, and you need to look at section 57. And so candour in disclosure is also paramount post-admission. There is a blending of the traditional and contemporary tests in the Legal Profession Act. We include both fit and proper person and good fame and character. But we also have one at section 9(1), paragraph N, which talks about a person being unable to satisfactorily carry out the inherent requirements of practice. This is a very important catch-all, just as fit and proper and good fame and character are catch-alls. This one is a catch-all as well, and is often used to look at the sorts of conduct such as drug and alcohol use or mental health, where a person's medical condition or their personal circumstances might impact on their ability to actually engage in practice. Family violence is relatively new to this area, but it's well worth talking about because it's a very interesting and important area for us. It is in the legal admission guidelines, but it is so briefly noted as to just say that a law student should disclose intervention orders and apprehended violence orders. The key issues, though, when you look at the cases, and if you look back at the case of Hines, which is an ACT case, and who was a Townsville practitioner now deceased, there was an effective debate about what was a serious breach of a DVO. There was, I think, probably a somewhat antiquated approach, and if you look at the approach the court took, they did not take the approach that I think a court would take now to family violence. If you look at the case of Ayobi, which is a Queensland case currently before the court, you will see that it is now treated as a serious issue, as it should be. Likewise, if you look at, and I'm not going to go through the facts of these cases because it will just take too long. Likewise, if you look at Rowe, Rowe was about a practitioner who was struck off for a myriad of offending conduct. One of those, one part of his conduct was to make unlawful allegations of family violence against his wife and to fabricate statements for court proceedings in the family court, I think. So the treatment of family violence has become serious, as it should, and so law students will now need to turn their mind to whether they have anything in their personal history that would require to be disclosed. And if you look at Ayobi's case, the court actually was very dismissive of the way in which the applicant failed to fully disclose. He disclosed a family violence order as just having been a consent order, and in fact the court wanted to see the detail of his wife's statement and get a real feeling for what actually happened. And so they will not just accept a tidy little disclosure, they'll require full disclosure of the background and the circumstances. This has got to be distinguished from sexual violence, which is has always been treated seriously, of course, but is really a separate issue because it often relates to criminal charges that have been laid. And so it's more akin to serious breaches. And the case of Franklin is a terrifying case in terms of the facts. I won't recite them now, but it's a terrifying case and shows that the court will treat sexual violence very seriously. It's important to distinguish between offences against minors. Again, I'm not going to go into these details. Or offences committed as young people. And there's a recent case where a young man who was a sex worker in a previous life was admitted despite having serious convictions. Again, I'm not going to go into the detail, but when you're looking at these cases, you need to always be looking at the fine balance of that particular case. Justice Douglas has said that a domestic violence order has been made against an applicant for admission is a serious issue. This needs to be heeded by any person who has a history of family violence, and that includes a history of family violence that did not result in orders or did not result in a breach. I'll just leave this quote up there, and this is from Franklin. This is a clear example of when someone's personal conduct, their criminal conduct, makes disciplinary matters the only proper response. The court is happy to say that the criminal conduct was so inconsistent with the qualities that lawyers are meant to have that it showed defects of character incompatible with being a lawyer. Academic misconduct is an area that you may already be familiar with. It's a common area for suitability, and it's noted in the guidelines at 5E. Our court has had a very strict approach to this matter since Chief Justice de Jersey, going back to AJG in 2004, and there's a line of authorities up through Lavery and Humsey Hancock, and Mark Thomas, the president of Caxton Legal Centre, has written a very good paper about this that's in my references. Academic misconduct is many and varied. It can be plagiarism, it can be failing to reference, it can be cheating in exams, it can be all manner of things. Generally speaking, the court will look at whether it is minor or major misconduct, and they will certainly refuse admission on the basis of any of these things. It's probably the most common area of suitability experienced by people like us that assist with suitability applications. What about student misconduct? And this is absolutely something we need to be aware of. The admission guidelines say that an applicant may need to disclose misconduct that occurred in the workplace, educational institution, volunteer position, club or association, if such conduct may reflect on whether the applicant is fit and proper. This could include, but is not limited to, offensive behaviour, workplace bullying, property damage, sexual harassment or racial vilification. If you look at the Human Rights Commission's report on sexual harassment in universities, if you look at a student who may have had a student misconduct complaint made against them, in my view, that would need to be disclosed, irrespective of the outcome. This also applies to practitioners, and if you look at Van Ness, a barrister who engaged in cheating in a CPD activity, I think from memory, you better read that just to make sure I'm not defaming Van Ness, but this practitioner engaged in some academic dishonesty and was disciplined. So it also applies after the fact, after admission. Drug and substance abuse is a very common one as well, in 5F in the guidelines. This is generally treated as Section 9. Are you able to satisfactorily carry out the inherent requirements of practice? There are multiple suitability issues involved in this. Often it relates to criminal conduct in terms of convictions, but of course the court is going to look at your recent use in terms of whether you have a propensity to misuse drugs or alcohol, and if you have recent convictions for drink driving or drug use, whether it be alcohol or, in cases of P and Darvinese, of course, serious drugs, cocaine, ice, and ecstasy. You may well need to deal with the issue of the conviction and the passage of time, but also whether these things give rise to any factors which might impact on your ability to act as a lawyer. Obviously, people who have major addictions have major problems engaging in legal practice. This might also relate to gambling, and there are a few cases coming through the pipeline at the moment about that. Centrelink, this is a very common one now as well. It relates to whether someone's a fit and proper person. Look at the guidelines at 5H, and the key issues are you of good fame and character. There's some good cases to look at. The case of Valvo in 2014. It really talked about your reliability. They're very concerned about issues of dishonesty. And of course, if you lie about the lie, that's even worse. I've given you that case there also, Saunders. And Saunders says that really we're treating people this way because this is about protecting the public from persons who are not suitable for admission. If you were prepared to cheat the system and to make a fraudulent claim against Centrelink or another department, then maybe you'll do the same about someone else or to one of your clients. Very important to make distinctions between a matter that was investigated and that gave rise to a debt and a matter that gave rise to criminal proceedings. They will need to disclose both, but a simple overpayment that was subject to the merits process is probably far easier to get around than a criminal conviction. Capacity is also very important. And again, the board itself will look at this as an early suitability matter, as will the court, and you just need to look at Doolan's case. Now, many of the other cases are looking at your past conduct and what does your past conduct tell us about your future trustworthiness? Doolan's case is also an example of how the court will look at your prospective behaviour in terms of your ability to engage in legal practice. It's a very fine line, I think, between disability discrimination and appropriate regulation, and I think the court is still feeling its way around these issues, but it is an emerging issue. It's Acting Justice Goddard's remark about Doolan. It was not about his diagnosis. It was about how he behaved and acted and the symptoms. Mr. Doolan was eventually admitted. There are some links with conduct issues and unsatisfactory professional conduct. There's no express connection. However, there's nothing to say that a Section 9 issue that arose after admission wouldn't be unsatisfactory professional conduct. There is an express mention in Section 419, which is professional misconduct, which is the more serious of the two. There's an express mention of the suitability matters in Section 9. And so conduct that gives rise to suitability, all these things we've discussed, can also potentially give rise to disciplinary matters for lawyers after admission. So I'm going very fast, so I'll leave some time for questions. Practical matters. Well, it's very important to understand the breadth of suitability matters, and I've given you just a very quick tour through those matters today. It's very important that the student, and if you are assisting one, seek advice about the options, and the best thing they can do is probably make an early suitability application. Full disclosure often requires you to go and get further evidence, including right to information releases and other things, so you can provide a full disclosure to the board. Otherwise, you'll be back and forth about what are the issues forevermore, while the board tries to, or the court tries to work out, is it a serious issue or isn't it? And written submissions on the law can be helpful, addressing the particular suitability matters that arise in a particular case. Giving you some references there, which are some academic articles and some speeches which look at the issues, and I'm happy to circulate some other links. I put together a set of links to the cases at another time. I think that's probably all I wanted to say, and I've left a bit longer for discussion. So if anyone's got any questions or comments, I'd love to take them.
Thanks, Bill. That was really good, and a lot of cases have come up since I last looked at these sorts of things when I was at uni, so I'm definitely going to be checking out some of your articles and cases that you've referred to. So I'll just remind everyone that there are two ways you can ask questions for Bill. So you can, on your control panel, press the button that looks like a hand, and we'll see a hand go up at our end, and you can ask your question via a microphone if you've got one available. Or the easier way, perhaps, is to just type your question into the question box on the control panel. So we'll see those questions come through, and I can read them out for Bill to answer. So, a good opportunity now if you are a student or if you're sort of heading down the track to admission, to maybe pop in any questions you have about particular issues or things you're a bit unsure about, and we can have a look at those now. Similarly, if you're a CLC worker and you've got students working with you, it might be a good opportunity to raise any issues or questions you've got regarding them. So I'll just give you a little bit of time. Bill, while we're waiting for those questions to come through, I've got maybe a small question. So we had a webinar last week on Social Security, and the issue of robo-debt was raised. I'm wondering whether that might have any bearing on suitability for admission for students who might have been subject to a robo-debt letter. What do you think about that?
A robo-debt letter would have to be disclosed, and I think if anyone had a robo-debt letter, they should consider, depending on the size of the debt, but I think they should consider applying for early suitability because the board is very careful to sort through Centrelink cases to look at whether or not there was any dishonest conduct, and even relatively small debts can include dishonesty. And so the quantum of the debt isn't the sole determinant of what you would do in this case. You would need to look at each case on its merits and say, well, let's say the person just completely failed to disclose their earnings and had no good reason to do so, and just intended to do that. The fact that they weren't prosecuted for that wouldn't change the suitability nature of that case. So I think students who have those sorts of debts need to get advice, and they need to think about an early suitability application.
Great. Yeah, so it is something, really important to note for anyone who's listening out there in the world with Centrelink. Any of those issues, it's probably best to disclose and rather than not disclose. Would that be right, Bill? Just in case you were unsure.
The first thing you would do is you would make a Freedom of Information request of Centrelink for a copy of your file, and you would want to get a copy of your entire file because it won't be acceptable to just give excerpts because there might be a view that you are being selective in your evidence. You would take a whole copy of your file and you would provide that, drawing the board's attention to the particular issues that gave rise to the debt and any things that mitigated the debt or showed that you had an intent to do it or showed that you were ill or there was some other issue at play. You want to show that the debt did not arise through dishonesty. And generally speaking, that's not that hard to do. Centrelink matters are relatively easy cases to deal with in the scheme of things, but certainly it's something they will look at closely.
So we've got a few questions coming through now. So in the interest of keeping any issues that people might be experiencing confidential, I might not read out people's names, but the first question we've got here is if... I'm
also happy for any questions where there's a concern about that. People can contact you, Carly, and they can send me an email. I'd be happy to talk to people about this if there's a problematic one, okay?
Oh, fantastic. So the first one here is, if I was to secure employment as a solicitor overseas, what would I need to do for PLT admission? Not sure whether that's within the scope of what you're talking about today, Bill, but if you've got any thoughts.
Well, I mean, I guess that if you are applying to be admitted overseas, then most of those processes will have similar disclosure schemes, and most of them will also want you to disclose whether you've applied for admission somewhere else. If you're applying in Commonwealth countries, chances are they will ask for um, proper disclosure about where you have previously been admitted and have you been subject to disciplinary or suitability issues. There is, I mean, there is a cohort of students who will never be admitted in Australia and are now travelling overseas to try and be admitted in other places. There are places that have far less onerous schemes in practice, and in fact, the scheme that we have in practice here in Australia now for admission as a lawyer is probably more onerous than any other professional scheme in the country. It's far more difficult to be admitted as a lawyer than it is as a doctor or any other type of professional. The requirements are so far above and beyond any other scheme that it has become very difficult. And there are as many that say this is problematic as who say that's a good thing.
Absolutely. So the next question here is what level of disability should be disclosed? For example, would you need to disclose conditions such as ADHD?
That's an excellent question, and I don't know the answer to that. I think that the most common examples of disclosure have been where people have been admitted to acute psychiatric care, or who have had a criminal offence that involved the mental health system. And so most of the cases that we see or are disclosed are where the nature of the person's condition will be easily found or will be present on other documents they're submitting. It's a very new area, and I don't know the answer to that. I think that's the sort of thing the profession has to come to grips with, that we cannot simply draw presumptions, stereotypes, or ableist conclusions about people's professionalism or their ability. I think it's something that we need to, probably our sector needs to look at, because there is no doubt that this system will discriminate heavily against those who have serious mental health issues. But yeah, that's a great question, which I apologise for not having the answer to, but I think it's something we really do need to work on. I'd be happy to look at that if the person wanted to contact me outside this lecture.
Fantastic, that's great. So I can maybe, if that person wants to send an email through so that we can make sure we can respond to you correctly. So the next question that's coming through is, what are the real prospects of a student that is currently bankrupt to obtain admission once that bankruptcy is discharged?
Well, I think there's a number. I mean, I'm not a commercial lawyer, so I don't have a background in bankruptcy work, although I've done quite a bit of it at a consumer level. It would depend on whether you were bankrupt personally, or whether you caused the insolvency of a broader company or an organisation. The detail of the bankruptcy is important. I think a small personal bankruptcy is different to a large commercial insolvency. I think you will definitely have some issues, and you need to start looking at the sorts of concerns the board has about bankrupt legal admissions. It's been a very big issue in the past, and certainly, yes, that's, if you have a prior bankruptcy, you absolutely need to do an early suitability application, no doubt.
Great. Okay, that's.
I can't say whether you're going to get admitted or not on the basis of just this. I mean, I think it's a serious suitability issue. So I guess I can say there's a chance you won't be.
Okay. So how would the court view a minor infraction on one assignment at uni? So if the minor infraction occurred when the draft checking facility failed to recognise any issues, would that be sufficient to deny admission?
Look, I would say that you need to look at as I said, the very good article by Mark Thomas, and there are other articles on academic misconduct. The court is taking a very strict approach to these cases. It has tended to look at cases in terms of minor and major misconduct. The universities themselves tend to categorise things in that way. The university will expect to see a copy of any committee decision about that misconduct. They really expect you to take ownership for that misconduct. And if you try to blame your academic misconduct on other factors, such as being stressed, such as being worried about your exam, such as mechanical failures in printers or things like that, there's a strong likelihood that they will simply see that you are lacking insight into your own misconduct. And so I would say that if it's a minor misconduct matter, the best approach is to do early suitability, make full disclosure, and look at the issues of what insight you have. Many people who have been involved in these cases suggest that students should engage in some ongoing mentoring about misconduct and ethics, and show that they are taking a course of conduct that corrects their prior conduct. But that's definitely one where you'll need to make an academic suitability, an early suitability application.
That one leads nicely into our next question. So, does major academic misconduct during the first year of law school mean that a person should apply for early suitability, or should they wait as they're sure that it won't happen again and then just disclose it when going through the admission process?
Look, I would never just disclose that through admission. I think that if you have major academic suitability issues, then you need to apply for early suitability, which you can do at any time. You don't have to be ready to be admitted to make an application. But of course, you probably need to do it at a time that is relevant. So I would say that for most people who, the person who has a major academic misconduct issue in their first year of university needs to take some steps to become a better student. They need to improve their circumstances in the eye of the court and the board. So they'll need to do certain things to improve their chances. And I don't mean things you can just tick off. I mean things that show a genuine and sincere approach to their situation and show insight into their conduct. So if you take a range of steps, including counselling, some mentoring, and make full disclosure, then yes, you've got some chance. It does depend on the nature of the misconduct, and it does depend on a number of other factors, whether you have, remembering that these things don't occur in a vacuum, whether you have other suitability issues. But look, I don't discount that someone with those matters will be admitted. They certainly won't be admitted if they don't take steps to A, correct their conduct, B, have insight into their conduct, and C, show genuine understanding and remorse for what they've done. If you try and tell a story that isn't candid, then you've got no chance.
Okay. So I think, again, another question around university issues. So if a student receives a warning email about plagiarism from the university, but nothing formal is contained upon her record or his record, does that need to be disclosed? I think I know the answer to this one.
Yes. Yes, that's a yes from me.
Absolutely. Okay, so that was the last question that's come through. Is there anyone else that wants to ask a question while we've got Bill here and he's happy to answer those? So feel free to write your questions into the question box or pop your hand up on the control panel and we can flick over to you to discuss that. Now, I've just got a hand raised from Susan, so I'm just going to see whether you still would like to ask your question, and I'll unmute you if you like. So you're unmuted, Susan, if you want to ask your question now. So it's a question about the references. Did you want to speak to us about that? Okay, no need to ask a question. That's fine. So got another question here. Okay, so Bill, are you happy to share your contact details to our viewers today if they've got questions about their own admissions?
Yeah, I'm not. I won't undertake to give detailed advice about each of these cases, but I think that I can. I'm happy to have a chat with people if they've got an issue. So I'll be pointing them in a direction of taking it on. So
okay, no worries.
yeah,
I'll make sure to.
When the people call through, it's important to just let our reception know that you're calling after the webinar. Otherwise, you'll just to be clear about why you're calling.
Sure. Okay. So I'll when I send out the information following today's session with the recording, I'll just pop the details and the contact details for the Townsville Community Legal Centre in the email, and you can contact Bill.
My email address is fine too, Carly.
Great.
That email address is my principal. That's fine. People can have that. That's the easiest way to make contact.
Yep, I will do that.
Trying to explain your situation through the standard process.
Wonderful. I've got a couple of thank yous coming through for that. That's good. Yeah, I think you can expect to get a couple of quick emails. Yeah. So I do have just a couple more questions and then we'll finish up. So what extent would traffic offences, for example, speeding, affect suitability? So not
if disclosed. Yeah, if disclosed, not at all. I mean, they're considered. They've always been considered. If it's a traffic offence that relates to drink driving or to injury, causing injury, it's different, and they will look at those very closely. But if it's just the run-of-the-mill traffic offences, then not a big issue. If you've got lots of them, it can be an issue, particularly if there's lots of them recently, and also particularly if they are alongside other suitability issues. So these things can have a bit of a snowballing effect, and so you've just got to be aware that what might look simple on its own becomes more complex in concert with something else.
Sure. So just a couple more comments. So in regards to the issues surrounding, plagiarism or university misconduct, we've got a question about whether university counselling would be sufficient to sort of counter those kinds of issues.
I don't know the answer to that. I think it's, I'm not sure. I think, yeah, I'm not sure there's a yes or no answer to that. Certainly one of the things you could do, I think there are other things you would need to do, including, well, obviously making an open disclosure about it, showing what you've done to deal with the behaviour. Obviously keeping a clean nose throughout the rest of your academic studies. But if you look at the academic misconduct cases, and if you look at the line of authorities, and there are a number of articles about this, they take it very seriously. So I think Mark, in his article, talks about some of the things that students can do. I would be speaking with a student advisor or with a lecturer that you can trust and have got a rapport with about what you might do to help. But again, it is a serious suitability matter, so the sooner you know about it and start dealing with it, the better it will be. If you leave it until the last moment, it will be a problem.
Okay, fantastic. Well, I think that just about rounds it up for today. Bill, you did mention that you would send out a reference list or links.
Yes.
Was that right? Great.
That'll just be the cases, yeah.
Okay, fantastic. I've just got a comment here that someone's not able to find the Corbyn and Carter reference. Do you know whether that has a particular journal article or location that you can provide? It's just not on the list here.
I'll quickly have a look now and I'll tell you.
Oh, wonderful. Thank you.
There's a couple that were a little bit hard to find. I'll track that down and come back to you about that one, and you can send out a message.
Wonderful.
I can't.
That's all right. I won't put you on the spot right now. Okay. Well, thank you very much, everyone, for attending and for getting involved in the questions. I hope that things have been cleared up a little for you now. Bill, thank you so much again for presenting today's webinar. I think it was really interesting, and we'll certainly be having a look through some of those newer cases that are coming out. Thanks, everyone.
Thanks, Carly, and thanks everyone for coming along.
Great. Okay. See you later.
Bye.